Horse in the front.
That's very good.
There you go.
Ready to go? Okay. Good morning, everybody. I'm joined here this morning by Assistant United States Attorney John Duncan, also New York State Police Captain Jeff Robb, lead investigator on the case Paul Olson, and I want to discuss with you the legal issues that happened today. I would caution some of you, I understand some of this is being broadcast live, so if parents are out there watching, this is probably not an appropriate discussion to have young children watching. This morning, an Onondaga County grand jury has returned a 37-count indictment in front of Judge Anthony Alloy against 29-year-old David Renz, whose last known address was in the town of Cicero. It is alleged that on Thursday, March 14th of this year, at approximately 8 p.m., 47-year-old Lori Bresnahan and 10-year-old Jane Doe, a child whose identity is known to the grand jury, left a gymnastics practice class at the Great Northern Mall in the town of Clay. David Renz, it is alleged, followed Lori and the child to their car in a parking lot. At that point, he brandished what appeared to be a pistol and forced his way into Lori's car and directed her to drive to a remote area of the parking lot behind the mall. In the parking lot, he used twist ties to bound Lori's hands behind her back, and then he made the 10-year-old child remove her clothes and put on a pair of pantyhose that he had brought with him. He then tied her hands as well behind her back. It is further alleged that Renz cut a hole in the pantyhose and began a sexual assault on Jane Doe. Jane Doe suffered extensive injuries to her body from the assault that required surgery to repair. It is further alleged by the grand jury that the defendant drove the victim's car out of the parking lot and eventually stopped on Verplank Road, which is just north of Great Northern Mall, and the car became stuck in the snow on the side of the road. The grand jury found that at that point, Mr. Renz attacked Lori, began to strangle her with his hands, and then attempted to tie her head to the headrest of the passenger seat of the car with cable ties. Lori put up an extensive struggle. The ties broke several times, and at this time, Lori told Jane Doe to run and get out of the car. Although Jane was had her hands tied behind her back, she was able to open the back door. She's a very extraordinary young girl, and she ran away. As she ran away, she noticed that Lori was able to break free and escape from the car, and at that point, Jane observed Renz chasing Lori around the car. We do not believe that Jane Doe witnessed Lori's actual murder. Within moments, two citizens, William Craig and John Hark, were both independently driving on Verplank Road in separate cars. They saw Jane and Lori on the road. Although they had the opportunity to drive by, they both stopped, they rendered assistance, and they called 911 at 8:58 p.m. They did not see the defendant, who by that time had fled on foot into the woods, and they undoubtedly were able to save little Jane's life. The New York State Police began tracking the defendant with K-9 units, began pursuing him on foot, and they were also assisted by the Onondaga County Sheriff's Office and the Air One helicopter. At 9:53 p.m., less than an hour later, New York State Police investigator Gary Darstein, who was on Route 57 and had been responding to an unrelated crime scene and was approximately 2 miles from the crime, began alone in his car to respond to the scene. He saw a person matching the description of the suspect. He stopped his car and then tackled David Renz and took him into custody. The defendant had the keys to the victim's car in his pocket. He had blood on his pants, on his underwear, and on his genitals. DNA testing has confirmed that the blood on Mr. Renz was that of Jane Doe. There is, as you might imagine, additional extensive forensic testing that will be ongoing. The New York State Police found a knife in the woods along the route that Mr. Renz had taken. The New York State Police executed a search warrant in Renz's home and found several CDs and DVDs that contained child pornography. Normally, in a case like this, Evidence of that pornography would not be admissible. However, we intend to prove at trial that several of the acts depicted in the child pornography possessed by Mr. Renz mirrored the attack that he performed on Jane Doe. State Police also located receipts for the purchase of pantyhose at a Walmart, an air gun at Walmart, and cable ties at Home Depot. Video surveillance tapes will confirm that Renz was in fact the purchaser of these items. The New York State Police, after an extensive search, were unable to locate the air gun pistol. The allegations are contained in the attached 37-count indictment, which was reported out this morning. There are numerous murder counts. To be clear, they allege intentional murder in the first degree, and that requires an intentional murder along with the commission of another felony. There are 4 counts of murder in the first degree. The 4 underlying felonies are kidnapping, rape, criminal sexual act, and sexual abuse. There are also murder second counts contained in the indictment. There are charges of kidnapping, rape, criminal sexual act, and sexual abuse. There are also possession of weapons charges. Lori's cause of death was 6 stab wounds to the chest and head with a contributory cause of strangulation. We have not discovered any evidence that Lori was sexually abused. All of the sex offenses relate to the child Jane Doe. I want to commend the extraordinary work done on this case by the men and women of the New York State Police. I can tell you that to a man and woman, they have treated Jane Doe as if she were their own daughter. I want to thank the media for protecting the privacy of Jane Doe, even though most of you are aware of her actual identity. You are to be commended for that. And I want to warn anyone that interferes with or tampers with this child's privacy in the coming months that the full force of the Onondaga County DA's office, the United States Attorney's Office, and the New York State Police will descend upon you with the wrath of God. I want to personally thank the United States Attorney, Rick Hartunian, represented here today by John Duncan, for his and that office's cooperation in this case as they continue their parallel investigation and prosecution of not only this crime, but unrelated charges as well. Media comments from this office will be very limited and restricted in the coming months so as to ensure that Mr. Renz, who is presumed innocent, receives a fair trial. And I assure you, and I assure the citizens of Onondaga County, that prior to this trial, this office will accept nothing less than the maximum sentence of life without parole on any deals involving Mr. Renz. Captain Robb, representing the New York State Police, has indicated he does not want to comment. John, did you want to say anything?
That's right.
Okay, and we'll be happy to take any questions from the media.
At this point, how is the child doing, and what kinds of services are being offered?
Jim, she has received the full services offered by the McMahon Ryan Child Advocacy Center. Those people over there have been nothing less than extraordinary in treating this child. The New York State Police have assigned, I think, one of their best people to work with this child, and he's just remarkable. How she is doing, having been doing this for 35 years, I would categorize her as doing very, very well. She is surrounded by an incredible, loving support system of people that care about her. Lori made provisions for her, and she's doing very, very well.
On that topic, how was she able to assist your office in securing this indictment?
She was an outstanding witness, and she will be an outstanding witness at trial.
She was able to relate everything.
She has a very, very good recollection of what happened. She's an extraordinary little girl.
He was chasing her around the car. Is that where they found her body and then he ran away? I guess I'm just a little unclear about how that played out.
Yeah, all of those details will come out at trial, but at this point, the last thing, we don't have any eyewitness other than Jane Doe. Jane indicates that she last saw Lori being chased around the car. The one thing that I did take away from it is that Lori died really saving Jane Doe. There's no question that she attempted to distract Renz so that little Jane could get away. And you know, the ins, the outs, who was where, and so forth and so on, that'll all come out of trial.
So those two passersby really were the key to...
I don't have any doubt in my mind that we would be here discussing an indictment for the murder of Lori Bresnahan and the murder of Jane Doe were it not for those two gentlemen. I have spoken to the state police. My office and the state police will both presenting those as small a token as it seems with an award next month.
Bill, were there any tips from the public at one point? We broadcast that you wanted to receive tips from the public.
Well, at this point, quite frankly, if anybody listening has information, absolutely call the state police. Prior encounters with David Renz, anything that you may have seen that night, that would be true in any criminal case, and certainly in this one. Once we kept his picture from you for a period of time, as you know. I appreciate you're following our wishes and not publishing his pictures until such point as Jane was able to be involved in an identification procedure, which went very well. I appreciate that. Now that you have his picture, if anybody, certainly call the state police or call my office, and we'd be happy to take any information that you have.
Is there evidence that he had planned this
well,
in
as
advance?
I indicated, Jim, you know, we have evidence of him purchasing prior, you know, well prior to the murder, twist ties, pantyhose, the air gun. So, you know, you draw your own conclusions from that.
Has he given any statements, or is he?
He was he gave no statement to the state police.
Where is he in custody now? And is he
I'm not sure,
special-
John. Have you guys got him locked up, or he'd be at the same building?
He'd be the same facility.
Yeah, and I don't know what his bail status is, other than to say he's not getting out. He's being held both on federal and state charges, and as I said, the U.S. Attorney's Office investigation regarding this crime is continuing.
And the difference in the 4 murder charges, are they one with some state, some federal? Is that how?
No, the 4 murder charges, let me explain that again. In New York State, since 1995, 96, we have murder in the first degree. Prior to that, murder in the first degree only applied to the murder of a police officer, when John and I were trying murder cases in this office. Murder in the first degree, now in the elements of that are an intentional murder committed during the course of a designated felony. In this case, the 4 designated felonies are kidnapping, a criminal sexual act, rape, and sexual abuse in the first degree. So those are 4 separate and distinct theories, if you will, that the grand jury returned indictments or returned counts on of the indictment. All of those are punishable by life without parole as a maximum sentence.
The child pornography that you seized at his home depicted scenes similar to what took place?
That's correct.
Is it rare to use child pornography in trials? You have to, is it?
Well, normally the argument would be, if I were to play defense lawyer for a second, as painful as that may be, to say that, Your Honor, we can't have this evidence admitted because it's not related to this crime and it's prejudicial. The argument that we will present in court is that the pornography viewed by Mr. Renz allegedly mirrors, in some very, very important respects, the crime that he perpetrated on Jane Doe. Now, sometime today, somewhere in America, some bloviating academic will get up on a stage and say there's absolutely no relationship between pornography and violent behavior. And everybody in this room knows that that's not true.
So, Mr. Duncan, just wondering, how does this impact your investigation of his earlier crime and also the...
It doesn't impact it at all, actually, given the magnitude and the gravity of this crime when it occurred. The District Attorney's Office and the U.S. Attorney's Office have been working hand in hand to coordinate both the federal prosecution and the state prosecution here so that we can both maximize our efforts in prosecuting this case, both on the federal side with respect to the child pornography charges and also on the state side here in relation to the murder charges.
So there'll be two separate trials and two separate.
There is currently a federal indictment pending, which was just returned about a week ago for the federal pornography charges. The state murder charges and the associated charges will be prosecuted in the state court. But we're coordinating, and both people from our office and from the DA's office are working on both cases.
There's been a great deal of criticism in the public that this man should never have been released on home confinement. What is your reaction to that criticism in light of what has taken place?
Well, obviously, given what has taken place, it's just a terrible, tragic event, horrific, hard to describe it once you hear the facts as you've heard them this morning. Judgments were made at that time. You can look back. The court record is there as to the reasons why Mr. Renz was released on an ankle bracelet. The fact that he cut it off, is something that's being investigated. That certainly happened in the case of the Colorado Commission's or prison director who was murdered. The individual involved in that case had cut off a ankle bracelet and was able to perpetrate that crime many days, not hours, after cutting it off. So, I mean, obviously, the impact of this, everyone feels it, from the judiciary on down, and obviously people will be looking at release of subjects in this situation in a different light in the future.
It's time to review this whole procedure?
Well, I think, every time someone comes up for a bail review, it's reviewed. You have the record. I'm certain as to what took place. You can draw your own judgments on whether that was wise or not wise based upon his history at the time. A judgment was made. Obviously, in retrospect, people wouldn't do that, but at the time, you make the judgment not now, you make it at the time of the bail hearing.
Were you aware at the time that he was released in this situation that he had been implicated in a prior sexual assault involving a minor?
No, I can't comment specifically on the details, but there was a juvenile record at the time which was sealed, and it was sealed at the time of the bail hearing, and to get those records unsealed usually takes some time and motions before a court to obtain that information.
Was that obtainable at the time of that hearing?
No. In the time frame of the hearing, it would not have been, and that's not uncommon to have juvenile records that are sealed that come up with respect to defendants.
Well, when it comes to a case where you're dealing with a child predator, okay, even if it's pornography, should those juvenile records be automatically unsealed so that prior to a hearing of this nature, a judge and everybody has a full awareness of the situation?
Jim, that's a good question, and one perhaps that the state legislature should take up in terms of modifying the current procedures relative to juvenile records, because there's reasons for keeping them sealed. If someone commits an offense when they're a juvenile, it should not taint them in later years, but at the same time, it would have been helpful to know the full content of what the juvenile record was about, but that's a cumbersome process, and within the federal system, the defendant is entitled to a bail hearing within 3 days of his arrest, and so if it has to go forward at that time, it does, regardless of whether you're able to get juvenile records unsealed or not. So that's something perhaps the state legislature should contemplate.
Would you want to weigh in on that, Bill?
Yeah, I want to weigh in on a couple of things. First of all, in America, you have a constitutional right to be a nitwit. All right, and when I look at the new format of Syracuse.com, which is unfortunate because I think every community should have a vibrant in-print newspaper. I look at the Marnell case. You see how many comments there were about Marnell, about how I let the family down back in 1982 because I didn't go for a murder one conviction and I plea bargained the case. Is there anybody on Syracuse.com that could just weigh in and say, hey, stupid, there was no murder one available to the DA. He didn't plea bargain the case. So I just read it, my family reads it, my kids read it, and I go on and I live a very, very happy life. Let me tell you something. And some of the things that I read about Judge Andrew Baxter were completely inappropriate and out of line. He made a judgment call based on all of the evidence. And he didn't just say, okay, Mr. Renz, walk out of the courtroom and promise to come back. He listened to both sides. He made the guy wear an ankle bracelet. He restricted him. And as John said, Department of Justice is investigating the ankle bracelet situation, the company, and so forth and so on. And a lot of that evidence will come out at trial. But to criticize Judge Baxter for what he did in this case, if someone has a crystal ball and know that someone's going to go from DEFCON 5 to DEFCON 1 in 3 weeks, please share that with me so that I can take it over to federal court and I can give it out to all the judges in Onondaga County as well. An alternative is, why don't you just shut up and let us do our job and let the facts come out? You cannot read the facts of this case and not start crying. You just can't. And the last thing in the world I need to see is a diversionary tactic to say that somehow, in some way, Judge Andy Baxter, who is about as fine a public servant as I've ever met in my life, is somehow responsible for this crime. The grand jury's indicted the person allegedly responsible for this crime, so let's keep our eye on the ball. And to answer your question, absolutely. There's no reason in the world why the DA's office, state police, U.S. attorney should jump through hoops to find out about what somebody did when they were the precious age of 14, 15, or 16. Thank you very much, ladies and gentlemen.